Let's move on. Discussion with the town board and Plan Commission on possible action by the Plan Commission for a certified survey map for June Grams Kemper. Roger?
Sure. Mr. Morgan Butler is here this evening. He is the petitioner on behalf of June Grams Kemper Estate. This is a piece of property that's being considered to be split from a parent parcel of 19.39 acres that Mr. Butler owned, or Mr. Butler and his brother both have partial ownership rights to. It's being mandated by probate that the division occur. The property contains a historic farmstead, a barn, and a number of outbuildings that, in their existing condition, are too close to the potential road right-of-way. And I would suggest that the Plan Commission take that into consideration as part of this CSM, acknowledge that they are worthy of a grandfathered status. They're certainly not going to go anywhere. One of the primary issues of concern on this project is Mr. Butler's contention that the 33 feet from centerline road dedication that the town is entitled to ask for at this time through the CSM process, he would prefer not to make that dedication. One of the other items in regards to the elements of the CSM is that actually part of Mr. Butler's property, the Kemper Estate, it falls within the city of Waukesha and needs to be properly illustrated on that CSM. For your consideration, I would encourage you to, as I mentioned, afford the grandfather status to that barn. Per the direction of town attorney, Mr. Butler has provided an affidavit identifying that property and that barn specifically have been in use as an agricultural element. Therefore, the grandfather status would be justified. Surveyors have completed a review of the property. Mr. Janelli can perhaps review the technical review letter that was submitted to the town. My recommendation to you is to approve the certified survey map contingent upon the dedication of the 33-foot right-of-way, addition of the municipal boundary as appropriate, and addition of the primary environmental corridor, which is mapped by the county, as well as inclusion of the items identified in the town engineer's survey review letter to be completed.
Thank you, Roger. Yes, my letter dated April 2nd just has really 5 items on it of some technical nature. Square footage of the existing structures is Chapter 7, Section 12 of the Town Code requirement, as is the need for any development plans. Of course, you're not developing, so we're obviously going to waive that. Lands to the south of the subject property should be identified on the CSM, and then we obviously strongly recommend the 33-foot public road use reservation be changed to dedication, as Roger stated. And then it must be noted that we contacted both the City of Waukesha and Waukesha County Department of Parks and Land Use, and neither of those agencies are approving authorities for the CSM.
My name is Morgan Butler. I'm an attorney. I'm also a resident of the town. My family's resided in this town for 70 years at 3857 South Mookie Way. I'm frankly shocked at the recommendation. It's time for a civics lesson. I provided all of you with a detailed memorandum citing both statutory, constitutional, and your own ordinances. Some of you may have heard of the United States Constitution. Amendment number 5, Bill of Rights, among other things, states that there can be no taking for a public purpose of private land without compensation. You are also, whether you know it or not, a township is a subdivision of the state of Wisconsin. It's not a home rule unit like a city would be. A home rule city can do anything that is not prohibited. The state or a subdivision of the state can only do what is specifically allowed. There is a statute addressing this situation, 82.14 of the Wisconsin statutes, acquiring rights to land for towns. Unless the acquisition can be made by mutual agreement, the town board shall is a requirement word in the statute, shall utilize the procedures under section 3205 to acquire rights to land for the purpose of laying out or altering a town highway. Section 3205 is eminent domain, where you go to court and you do have the right to acquire land. You have the right to acquire my land, but you have to pay full price for it. That's the Constitution, that's the state statute. What you are doing in trying to coerce me to give the town land in exchange for a land division is extortion. And the town and everyone who votes for it will be in circuit court, I absolutely guarantee it, within 30 days if you attach a condition that I give land for no compensation. It's the law of the land. Hopefully Mr. DeLamore has reviewed it. Additionally, under your own ordinances, it specifically says dedicated or reserved. A dedication is a transfer in fee simple. So if I dedicate that 33 feet, it's yours. Right now, it's mine. I can reserve it, which gives notice to future buyers that they can't like put a structure there or something, because it's the whole statutory phrase is it's reserved for future purchase by a municipality. So you can buy it anytime you want, but I'm not giving it to you. And if you pass a motion saying, I must give you something to which you are not entitled, that is extortion. And I will see you in court. I've been working with this town for a year on this. And the reason that it's taken a year is nobody on this town seems to have ever read your ordinances. This business, and it appears again in this stupid report about ancillary buildings. Read your ordinances. It's not an ancillary building. That barn, which has stood there and isn't moving, it's been there since 1885, is the primary structure on the property because there's no residence and it's the biggest, most important building on the plot. That makes it the primary building. It's not an ancillary building. Read the ordinance. Anyway, I'm very emotional about this. I'm going to get my rear end chewed out by the probate judge on May 29th because this is not done. And either this town is going to pass it or please then deny it, because that then gives me a right to take it to circuit court to straighten everybody out about what the law says. I've been a highway attorney for the Ozaukee County Highway Commission for 8 years. I know more highway law than anybody any of you know. And you're in a losing position if you try to force me to give you land. That's all there is to it. You can't do that. I'll answer questions if you wish.
Hector, I'd like you to weigh in on that.
On May the 8th, Mr. Butler was contacted by Mr. Dupler after Mr. Dupler and I spoke, and he wrote to him, also please be aware that I have conferred with the town attorney, and he recommends that if this issue is not resolved, the town will have no alternative but to deny the CSM due to the 60-day approval requirement. Any research by the town attorney will require time that we cannot afford at this time without extending beyond the approval deadline. There's no question that Mr. Butler has put together what he termed a memo, and he placed it in front of me just before the start of this meeting. The complicating dimension here is that there exists possibly in what we now call Milky Way Road, forgive me if I'm confusing the name, an ancient road, and there are certain doctrines that apply to the rights there. The reality is that in this state and in this country, the very act of zoning, the very act of subdividing constitutes a form of encumbrance upon private land, a limitation of the rights of the property owner. And in this particular situation, I'm not in a position, given this time frame, to opine whether Mr. Butler is correct or not. We spent a considerable amount of time in our office just basically attempting to persuade him that there was a mechanism that was available to qualify the division of this particular parcel if he would demonstrate that it had a non-conforming status. It was our office that recommended that he provide an affidavit. It was our office that said that that's something that had to be determined by the town. Until recently, my understanding is that Mr. Butler had not even paid the fees associated with his requests to the town. There's no question that he's got a pressing probate matter, but that is not something that is of the making of the town. My understanding is that he has now paid those fees. I can't give you a definitive response to the assertions of Mr. Butler because they were presented at the 11th hour.
You're a town attorney, you should know this stuff.
And you're an attorney and you should know the importance of timeliness.
Roger, we talked briefly before the meeting. You said that you had a conversation regarding ancient roads and that was superseded by current statute.
That's my understanding, as was explained to me by a licensed surveyor, in that state statute 236 with empowerment to the town has the right to require the dedication of roadways through the CSM process, through platting process. A CSM is a minor plat. So all the laws of platting apply to a CSM, and they're certainly within the town's rights to request that. Not only that, I talked with...
Specify the statute, please.
236, I don't know which one off the top of my head, Mr. Butler.
If it was the one that you included in your memo to me, that's absolute nonsense. This is not home rule here. You're a division of the state. I just told you, I gave all of you a copy of the state statute, and it doesn't talk about zoning or anything else. You either, if you're absent an agreement, which you certainly don't have for me to give you a third of an acre of land, you have to go through eminent domain, period. And if I have to take this to circuit court to teach you a lesson, I will, because the probate judge says get this thing done. So we're going to be doing that. And guess what? Whoever wins, the other side gets to pay their attorney fees. So, you know, don't be thinking you're going to be getting a reimbursement on this.
For the information of the town board, I really don't know what the basis is for Mr. Butler's asserting that whoever wins gets to pay the attorney fees. the controlling rule in the state of Wisconsin is what is commonly known as the American rule. And the American rule provides that a prevailing party does not get attorney fees in the absence of a contractual agreement or a statutory provision. It would be my sincere recommendation to assist Mr. Butler that the town, if it considers rejecting the CSM for the reasons that have been expressed, namely that his position has not been examined, that I be authorized to communicate with the probate judge and explain the difficulty that is present here, and that the town, if it rejects the application at this time, do so with the understanding that Mr. Butler is at liberty to reapply without prejudice, and that the fees associated with that reapplication would be waived. It's a matter of, as I see it, basically trying to do this in a rational, thoughtful way, rather than simply threatening people to take them to court. That's not the desire of the town. The desire of the town.
The desire of the town is to demand that I give the town 1/3 of an acre of land as a condition of this property split.
I'm speaking only to my recommendation, Mr. Butler. I think that this is something that should be done in a careful way, because there are potentially other properties situated along this roadway that at some point will come forth to be divided in some fashion. And it's the fundamental responsibility of the town to treat all people similarly situated in a fair fashion. It's unfortunate that you, the state of your mother, is the first one to come forward.
No, it's not, sir.
Well, to my knowledge.
The first one to come forward was the Moyer property directly to the north of mine. They just moved bulldozers into his front yard talking about this 33-foot easement, and I took them to court and destroyed them. And they ended up paying for every inch of land they took. So.
Well, Mr. Butler, I'm speaking only to my experience here. I'm sorry, I don't have the roots and knowledge that you have in this community. I merely want to do the best that I can under the circumstances.
Mr. Butler, if we were to deny the CSM, and if Attorney De La Mora was able to communicate with the probate attorney, probate court, and then
30 days, sir. I have 30 days from an adverse decision on your part. I'd give you 10 working days. At the end of that 10 working days, if I didn't have an approval, I will file with circuit court. Because I've been fooling around with you people, not you specifically, but the town for a year on this. And it's been holding up probate for a year, and I'm ready to go forward. So believe me, the judge will be explaining the law very carefully to everybody. I already know what it is. Apparently none of you do.
I do not, I am not an attorney, so I can tell you point blank, I do not know what that law is, but I would like to engage counsel and get an answer for you so that we're all on the same page and get some resolution for you as soon as possible. I don't think that 10 days is out of line, considering the fact that he's been
I've already provided you with the research.
In play for a year.
At 6:30 this evening, sir.
Regardless.
I'm saying with this, maybe you could get it done in 10 days.
The concern that I have is for the town to take formal action to accommodate it. That there is no meeting schedule of the Plan Commission in 10 days.
Could we negotiate on 2 weeks? Give us a couple of weeks for this? See if we can get it done.
I've
If we
been
turn
working
down
on
the
30
CSM.
days. Believe me, I'm done going round and round in a circle with the town.
You will not be
So
put around in a
if-
circle with me.
If I don't have a definitive go-ahead, you know, say, okay, we realize we're wrong on this trying to steal my land, I'll work with you, you know, to the next meeting. But if you haven't come around and understand the law, I will go to court because the judge will explain it.
You'll have communication from us next week.
That'd be
I
good.
can't tell you what the communication is going to be, but we will be talking with you. And we will
Wonderful.
engage counsel and
Just so
figure
you
out the
understand my
problem.
position, that's all I'm trying to do. I prefer working with you, but I'm not gonna, we're out of time.
I understand.
Thank you very much.
Thank you. Dan?
I have a couple of questions, I guess. The ingress egress easement on the south side of the property that serves both lot 2.
Excuse me?
The ingress egress easement that you show on
Yes, sir.
on the south side that serves both lot 2 and the property to the west
To
of
the north. It's a property to the north on Milky Way. If you're familiar with that spot, there's a very, very steep hill there. And that drive is right at the cusp of the hill. You have to exit there in order to be able to look at the flat part and to look downhill to see what's coming up.
I think we're talking about a different spot. We're talking about the easement that you show on the south side of the property.
Oh,
It
okay.
goes all along the south edge. That serves both lot 2 and the property to the west of that.
No, it would not actually, lot 2 is, it will be excluded from that because we're saving, there's a much larger piece, well, actually, no, it's a larger, it is lot 2, yeah, that serves the drive, plus the state of Wisconsin's got an easement over that, plus the Stimpert house, it's a half-mile in, is all
Covered under that same easement.
served in that easement. My lot 1 will not have a right to use that drive.
That has access direct to Milky Way Road.
Pardon?
That has access direct to
Exactly,
Milky Way Road.
exactly.
I was just making sure that lot 2 didn't become landlocked, because without access.
No, 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 they will own the strip to Milky Way. That's attached to that piece, that parcel.
Okay. It appears to me that the only discrepancy that I see so far is this 33-foot dedication. I think I support the land division and the CSM. Can we, as the plan commission, recommend approval and leave it up to the town board to resolve that issue? Is that an appropriate situation to be in?
Yes.
I'll move approval of the CSM with recommendation that the town board resolve the 33-foot dedication or reservation, however it may turn out, along the way around.
Second.
Discussion?
What's the current date of the application on the CSM?
March 5th is what I have on mine.
So we would run into a challenge with the 60 days.
Mr. Butler granted us a 30-day extension essentially in order to get to this meeting. But if we waited till the next meeting, it would certainly expire.
So we'd have to take that into consideration and whatever that piece gets worked out.
Let me ask a question, not getting ahead of ourselves, but assuming that we're persuaded to agree with the motion that you have made. Again, getting a bit ahead, but are we, can we expect then that Attorney De La Mora, you would provide a written analysis and recommendation that the town board could consider at its next, I think, regularly scheduled meeting on May 23rd? Is that where we're potentially headed? And does that then take care of, it addresses the timing issues? And again, for my purposes, I mean, I will confess that this is beyond me. I do that without apology at all, but I think, Hector, we need then a written analysis and recommendation from you upon which to rely, because this is beyond my ability to understand and sort out. So, support the motion at this level if that's where we think we're headed.
Anybody else? All in favor?
Aye.
Opposed?